I know that Bob anticipated not being here, and I have heard nothing different to indication that he would be available. So Bob, I'm sure, is not going to be with us. Anyway, let's just call a meeting to order. It's about 1:07, a little late. Let me make some notes here.
Jim, I just want to point out before we get started, I have a hard stop at 3 o'clock.
Okay, that's fine. Hard stop at 3 o'clock won't bother me. Let's put it that way. Okay, we have the agenda before us. A couple of comments. As I think everybody should have the information that Colette sent around yesterday. We'll add that to the agenda at the bottom of the above scheduled next meeting for discussion of where we go from here with those particular items. Another just an item you can see under new business, develop formal. That means that should be developed format for submitting bylaws proposals to the board. That's a typo there. Other than adding the 3 items to the agenda, do we have anything else to add or for that matter, delete from the agenda?
I do not.
Okay, if there are no further comments, we'll consider the agenda approved. Any comments on the minutes of the prior meeting? They're again fairly extensive, mainly because I believe we should add as much information to the record as we can. It's got the report that we submitted, the annual report that we submitted. Also, we have the initial draft of Bob's instructions for updating the governance document review. As I indicated in our message, we're going to delay that consideration as well as the current governing documents review till the next meeting, so Bob can be with us. Any comments on the minutes? Okay, if there are none, we'll indicate that they're approved. I don't see anybody else but us on here as far as the attendees at the meeting, so there are presumably no public comments. Let me move right on to an unfinished business now. The unfinished business item is just a review of what happened at the bylaws work group meeting on the 3rd, a little more than a week ago. Now, obviously, things have changed since then. We've had input from Camilla, I'm sorry, Colette, that's going to be added to our effort. But the intention right for this initial part is for me to give a couple of comments on where we came out of the bylaws work group meeting. And that's on the status review that was sent around both before I sent the materials for the meeting as well as with the materials for the meeting. Josh, if you could put, this is the summary itself. Can you put up the status, the spreadsheet status?
Is this not it?
That wasn't, no. I don't see anything right now. That's the summary.
Okay. You mean the Excel file?
Yeah, that's correct. Yes.
A second.
Yeah, that's what we're talking about here. Unfortunately, the material is kind of separated, but let's go with what we see there. there are basically two groupings of information there. Again, recognize that this is the status as it came out of the work group meeting, and it has to be updated from inputs we received yesterday, and I have not done that. The green indicates those proposals where we are to proceed as we have indicated in our information that we sent to the summary that we sent to the bylaws work group. In effect, we're given a go ahead to put our proposals in a format for the review by the board of directors for those items that are indicated in green. Now, right off the bat, the one at the top will change from green to red, but continuing on, there's 3 items that show in red on this status. One of which is the one at the bottom of the sheet we're looking at, and that's where we are expecting input from the Association Council on the ARC committee provision that's in the bylaws, and the questions about the whether it's an overreach, what's in there regarding the authority that the board may have regarding the ARC committee itself. That input is not been received, and it's up to me to get back to the council and ask him to give us his input for that. The other 2 items deal with first the search committee and the associate membership consideration that we have in our considerations that we added as an input from the executive council. The current plan coming out of the work group is that the search committee will be an item of discussion at the board level. And tentatively, it's been planned that would be at the December meeting. Now, the discussion of that is later on in the agenda, and I'll just hold that at that point. The same goes for the associate member consideration. That is also intended, coming out of the work group, intended to go to the board of directors for a discussion of the associate member participation in association affairs. Originally, it started out as, well, can associate members be committee members? Well, the discussion extended beyond that to more of a far-reaching possibility of consideration of associate member participation in association affairs. And that is now considered something that should go before the board of directors tentatively in January for discussion purposes. So there are basically 2 different categories coming out of the work group. One are those provisions in red in which we are able to proceed forward with how we're going to propose, what we're going to propose. We've got already summarized what we want to do, but putting in format our proposals to the board of directors. And then the other category is there are 2 categories, or 2 items in particular, that are slated for discussion at the board level before we proceed further. The third is the ARC consideration, but that's a secondary item. So that's what we came out of the work group with. Now, again, that's just a summary of where we stood coming out of the work group. As I said, the status will change because of 3 items that we've received. Is there an understanding of where we stand with this status, in particular, with our proceeding to begin to formulate actual written proposals that will go to the board of directors? Is that do I need to further elaborate, or do we need to further discuss that? We will have to discuss how we're going to do that. That's in a later agenda item. Is there an understanding of where we stand on proceeding with our effort?
Yes,
Okay. Okay, well, let's, I don't want to, I don't want to make it appear as if we're proceeding further on now without recognizing that we do have three items.
you're going, Jim.
Uh-oh.
Josh?
Yeah, I'll see if I can get him back.
Is Steve still here or did we lose him too?
I'm talking to Steve as well. He's having trouble joining.
Okay. We need some elevator music.
Yeah.
Keith has a guitar.
That's true.
Nobody wants to hear that.
Are you saying it's not a hidden talent?
It's not a natural talent.
Gotcha.
So Colette, just FYI, we don't normally have these many connectivity problems. This is kind of unusual.
Yeah, that's too bad when it happens, huh?
Usually all of it happens trying to do the initial connection and then we're all fine once we get
Yeah.
on. But in the middle, I don't think it's not raining outside, is it? I mean, because I am here in Ocean Pines, but I don't.
Well, it rained this morning,
Yeah,
and there's certain areas of the pines where if they get enough rain, it starts to
right.
seep into places it shouldn't seep into.
So I see that Steve Jacobs sent some recommendations regarding two of the charging documents that I sent, the
Mhm.
owner of record issue and the timing conflict in the candidate verification.
Mhm.
So it looks like good input.
I can't remember. He may or may not have been part of our previous discussions when Keith and I were talking about having some of these discussions because he's a very new member.
Okay.
He officially was part of the last meeting, but he was, that was his first real meeting with us, I think.
Okay.
So
So he may not be aware of what you guys had
what
discussed
we've already,
previously.
yeah. And I didn't, because he sent it right before the meeting, I didn't really read it all the way through yet, So.
Well, we
All right.
technically,
I'm back. I'm hanging up, Josh. All right.
Welcome.
I'm not sure where we are, to tell you the truth. The next, again, not to create an impression we're bypassing the input that we've received and have to discuss. But what I want to do now is go specifically to what comes next. And that, as I understand it now, would be the search committee discussion before the board of directors. And Colette, how do we expect this to proceed?
Okay, so typically what would happen is the liaison would prepare a topic for board discussion document in which the document itself, it articulates what the topic of the discussion is and the background on why the discussion is needed. And I think in this case, as would be in other cases, we may suspend Robert's rules to allow you, Jim, as chair of the Bylaws and Resolutions Advisory Committee, to engage in discussion with us. And so if you wanted to present kind of your background, kind of a statement of background and position, I think you'd written it up in this document that you shared with us, what your committee's position is, then that would give us a jumping off point for the board to discuss, kind of what your thoughts are.
Okay, I agree with that. I would suggest whatever that what we have in that summary be provided to the board so that they have that in hand.
Yeah, so do you want me to just incorporate that in the
Well,
topic of discussion form, or do you want to send that to me as a separate document, a position paper, so to speak, from the committee?
I'll go ahead and do that. There's a minor typographical error, and I can correct a typographical error and make sure that there isn't any other area that may need some clarification. But why don't I
Okay, and
review
then what
that?
I'll do is, yeah, and I can make that an attachment to the
Okay.
discussion topic form, so the board would be expected to review that ahead of the meeting and be prepared to discuss.
Okay, do you have any idea when the December meeting might be?
It is, oh gee, we don't have a calendar. John had asked that we make them the third week of the month because the financials come out. So the 15th, I think he would want it to be after the 15th. So I would say possibly the 18th. That's the Saturday before Christmas. Let me
Okay.
get, so, let's shoot for that. I will
Okay.
get with Larry, although the presidency of the board could change as a result of the hearing on Monday too. So, but I think we need
Okay.
to go ahead and set that date so that
Okay.
people can know what their target date is for their preparation for the meeting. So I'll get back to you on that.
Okay. With regard to the committee, any comments on proceeding forward with this, how to do it? We've talked about, Colette's pretty well outlined that the typical way this kind of thing is handled. Any comments, inputs, ideas regarding this? Essentially, we'll be waiting for the board to give us further guidance on what direction to go with the search committee issue.
I think what she outlined is appropriate and right. So I'm glad that she said that, because I know that in the past we've talked about how this works. And so I'm glad, Colette, that you said that and explained the process. And I think that's correct moving forward.
Okay. I got another message come up on my screen. Whatever, I click not now, so hopefully I don't disappear.
Did you read it before you click not now?
It appeared to me to be an update of a Windows update.
Jim, we should have Steve Jacobs joining. I'm not sure if he can hear us.
Yeah, I can hear you, and I'm on audio only.
Great.
Okay.
I don't know.
All right. Well, I think that takes care of the agenda item on the prepare for the board meeting. The next is a kind of a planning, well, not kind of, it is a planning for going forward, and going forward in particular with regard to putting these proposals into a format for consideration by the board of directors. Now, this is not something that's going to happen over the next week or two, or meeting or two, for example. And we need to make sure that we know how we want to do this. I believe I suggested that what we would take to the board of directors would be a marked up or red line copy of the current bylaws, indicating the changes to the bylaws that we were recommending. Now, along with that, there would have to be an explanation of the changes, the why, what they expect, what they're doing, why they're doing the background, whatever, however you want to express that. I think I also made a comment. I think that a red line markup is probably the thing that most people would be familiar with when they're trying to see what's being changed in a document. I'll call it an example, and this goes to the actual consideration in a referendum, but I'm not trying to get that far ahead. But what was done in the referendum for the 2008 bylaws is there were a red line markup was prepared. As I recall, it actually went out in the voting package. There may also have been a clean copy go out in the voting package, but there was also a summary of changes that was some 5 pages long. And what it did was by section indicated what changes were made within that section and a reason why, background and why those particular changes were made. I'm not trying to get ahead to where a referendum preparation is being made, but that kind of an approach, I think, would fit going forward to the board of directors. Now we covered the bylaws in the context of topics, not necessarily section by section or subsection by subsection. But be that as it may, there has to be some kind of consecutive, understandable description of what's been changed or what's being recommended to be changed. At any rate, that my ideas are we would at least be going forward with a red line copy of all the changes we're proposing with some document that provides a description of what the changes are and why and the background sort of thing. I think that's my thinking on how we would go forward. Now that we're ready to start putting these proposals into a change format, that is how we would, my suggestion of how we would proceed forward. So anyway, I offer that for comments.
Jim, may I interrupt for just 1 second? And I apologize for getting here late. I still don't know what's going on with my link because I haven't had a problem in the past. I am curious though about the 3 attachments. Have we covered the 3 attachments?
No, we have not. No, we have not. That will be next on the
Agenda.
on the agenda.
May I ask one other question? And again, I apologize. I sent out now probably almost an hour ago, an email to everybody with some suggestions. Did anybody get that?
I haven't seen it. I'm sorry.
Okay.
I saw it.
I got it, but I haven't had a chance to really read it.
Okay. I just wanted to catch up. I apologize.
Steve, I saw it and I can put that in the chat for everybody too.
So
Okay.
can I just comment about that real quick? So Jim, I guess I'm going to ask you for some guidance on this. So in the past, we've talked very briefly about the open meetings requirements and our obligation to conduct business in a public manner. That's why these are recorded and that's provided. And we talked about discussions outside of the meeting, for example, via email. And so it was kind of my understanding that we should limit our discussions via email outside of these meetings to a minimum that particularly would not include new business and would not be an agreement on this or that. Like I know we pass red lines around that come back to you. That's really just administrative editing of things we've already agreed to. But should we be having discussions such as recommendations on new agenda items via email, or should we hold those until the meeting and then only bring up those items in the next meeting.
Okay, this is always a sensitive topic, let me put it that way. My understanding is that decisions cannot be made outside of an open meeting. Now, there is the informal action consideration where we have unanimous agreement on a specific action. But to debate issues and come to an agreement on an action outside of an open meeting is not permitted. It's a violation of the Open Meetings Act. Exchanging information, I don't believe is considered a violation of the Open Meetings Act. Obviously, you can stretch that, you know, what you're considering exchanging information and the consequences of doing so. But I don't believe that we are restricted by passing back what we think about a particular issue. And these 3 items that are being added to our effort may fall into that kind of a category where it to advance what we're trying to do may include exchanging information and thoughts on what we feel, how we think about the particular issue in question. And I don't see that as an objection, as long as it's clear that we're exchanging our ideas, and our ideas would be further explored in an open meeting and decisions come forward that way, not in emails. Okay, I agree, you agree, she agrees, so that's it. No further. We've agreed that item's closed. That you know, that's kind of a simplistic approach or a comment, but that's not permitted. As long as we bring forward what our thoughts are and the reasons behind our decision and our decision in an open meeting, I think we can exchange information.
Thank you. I appreciate that. That makes sense to me.
Jim, if I may, I sent that email around only because I thought it would be easier for people to have a hard copy as opposed to trying to keep reading the same words over and over again. It was not my intent, and I think I labeled these as suggestions. That's all they were. I just thought it'd be easier to do it that way. If I overstepped, I apologize.
Well, in my scramble to try to get in the meeting myself, I had not gone back and read my emails. Well, I could do that right now if I need to. Hang on. I'm reluctant to go out of this screen.
Well, Josh put in the chat what Steve had sent in the email. If you can see the chat box here.
Let me see the chat.
It's the one that looks like a speech bubble.
Yeah, I'm looking here.
It might be highlighted if you haven't read the message yet. It's in between the little people icon and the hand.
Okay, I've got to click on something here.
So these are recommendations related to the 3 new items.
Okay.
So I would suggest we hold this for a second until we get through what we're currently talking through, and then we can, because I also have some recommendations, and then we could talk about them then.
Right.
Okay.
That's fine.
Just my
All right,
recommendation.
well, with regard to how we proceed forward, any thoughts on that in particular? I've mentioned a summary of changes that accompanied the voting package for the 2008 referendum. I have a hard copy of that, which I've reduced to a Word copy. Just as an example of what was used as an explanation of bylaws changes, I can send that around so folks can see how that in particular was done. Again, there was a red line copy available. I believe also sent around with the voting package was a clean copy of the draft changes. Of course, once you have a red line, you can get a clean draft copy by accepting changes. Yeah, Steve.
So my 2 cents. I like the idea of, first of all, submission to the board, the red line copy. I also like the idea of including with that the summary of changes with the language in it that could potentially be reused down the road during the ballot initiative to explain the changes, right? So, I mean, if the board wanted to tweak the language, change it, whatever they could, but we could potentially do some of that work up front as part of our explanation of why we recommended what we did. But in thinking about this, now I have a question, and I apologize if this is a little bit off topic, but I think it applies. We don't really have a process, do we, where when we submit bylaws changes to the public to vote on, that they can approve some and not approve others. It's an all or nothing thing, isn't it?
Yeah, that's correct. Whatever is submitted, you either approve or disapprove. Now, I have to back off of that and reconsider to a certain extent. It's possible. No, I don't want to say it's possible. Could you have a vote on individual changes as opposed to a vote on a complete package? I don't know.
Well,
I wouldn't dismiss that out of hand. Maybe that could be done.
Well, so my experience with the PTA stuff, that's how we do it. We put forth, our bylaws committee puts forth the recommended changes. We highlight, like you're talking about, and show what portions would be changed and state that everything else remains the same. So as long as there's no changes in that other stuff, you're really just voting to approve the new changes. I mean, and we could do that, the other way too, that if there were no changes being made at all, that could have been a recommendation by the bylaws committee to say, we are not recommending anything be changed or updated, and it's good to go for another 3 to 5 years before we review them all extensively again. You know what I mean? Mm-hmm. But instead of just doing a whole package each and every time and showing every little spot, only focus on the recommended changes and updating portion.
I would like us as a committee, if we agree to this, that we submit that as part of our recommendation, that due to the number of changes that are involved with this, that on the ballot, as you said, they be submitted as separate things to vote on, because there may be a number of items where we get complete consensus with people, and there may be other items where we get no consensus, and we don't want to off track all this work that's been done to date because we can't get consensus on 1 or 2 items. So I hope that it seems like we as a committee, if we think that's a good idea, we could just include that in our suggestions to the board, and obviously the board will do what the board does. But with a package of this size and the number of changes we're talking about, seems to me that that's a necessity.
Yeah, I do not know of there ever being any consideration to that kind of an approach. It's that the 2 bylaws initiatives in the past, let's call it 20 years, have one been the 2008 comprehensive change which was a major change throughout the bylaws itself. And then there's the referendum on the bylaws, a singular topic change here in the last year or so. Before that, all through the period of time from 1984 to 2008, there were any number of individual board-approved bylaws changes, but here again, it was a limited number of topics changed, and at that point in time, it was changed. There were changes were made by the board, not by referendum. And these are membership. We're now at a point of membership referendum changes, not a much narrower amendment approach by the board only, which is a completely different situation. Okay, well, I think that's something we need to put on a consideration as we go forward, that we change the possibility of changing provision by provision rather than having to accept all provisions or reject all provisions.
Right.
I just want to provide one last thought on that, please. So we know that from the last bylaws change, which was 2008, right, that the voter turnout on that vote was pretty low.
That's
I want
right.
to say it was under 40%. And I could see how people could get frustrated when presented with a huge package of changes that they have to accept all of it or none of it. And I could see where people might get frustrated with it and say, I'm not voting on this because these things I agree with, but these things I don't. And I have to either disagree with the things I agree with, or I got to agree with the things I disagree with and just choose not to vote on it all. So potentially by dividing them up into separate issues that people can vote on separately, we might get better voter participation in that.
Mm-hmm.
I don't know. Go ahead.
May I ask a question?
Sure.
I'm a little unclear as to the size of the package of changes to the bylaws we have to deal with.
It's in the summary that it's a multi-page summary, about 13 pages. Josh, do you have that summary you can put up? This is the one
I
that's.
can't see it anyway, so that's.
Oh, I'm sorry.
Yeah, one
Okay.
second.
Well, okay, never mind.
This is the what you sent out, the Bylaws and Resolution Advisory Committee. Is that?
No, it would the topic, the file name would be something like bylaws summary. Hang on a second.
It is called Bylaws Summary.
Yeah, headed bylaws summary. There's a cover page that says this summary includes the bylaws proposals by the Bylaws and Resolutions Advisory Committee in response to what we were given by the work group stated September 17th. That's the cover page.
Okay, I'm not seeing that. Okay, well, the only reason I'm asking is, in part, the idea that we would, well, I guess part of this, it's really up to the board to decide how it wants to proceed. So we would be making a recommendation to them in that regard. That said, I don't know, I have a hard time envisioning that the membership of the association would be more inclined to vote piecemeal by piecemeal as opposed to a single document. Assuming the single document is informative enough, it could be a lot of these changes are just technical and correcting, for lack of a better term, and there's fewer substantive changes. I don't know. I'm just, I don't. Go ahead, I'm sorry.
It's what's the substantive versus somewhat technical, kind of half and half for the topics that are being considered. Now that may mean the more recent three that we're going to be talking about, that could be very much a different story.
Colette?
Yeah, Jim, I have a question.
Yeah.
This question is for Laura. You've been through this process before of updating bylaws and having them voted on by PTA membership. Is that correct? And do you have any experience with piecemeal vote versus package vote?
We usually do, we usually present all of the changes. They're not as extensive as this homeowners association one. There are quite a few more sections in this kind of bylaws package than the PTA ones. Like the PTA ones, I have we're only allowed to change certain spots in the bylaws. Everything else has to stay as written by the state PTA. So
Gotcha.
that limits that lessens some of the package that we have to even deal with. But it really depends. Sometimes a unit might only have one or two changes, and so you can vote on them together, and say, yes, we approve this recommendation to change it. I could see doing it individually if there were topics that, as Keith points out, may have one draw that most people are going to automatically say sure, and then another position that somebody might say no, I don't agree with that, and they wouldn't want to vote on a whole package deal. So I really think it would just depend. I mean, I could see us doing it either way, but what we do is that we're not approving, we're only voting to approve those changes at that time that are presented, not like every whole part. None of if everything else is staying the same, we don't need to actually say we're still approving it because it's already been approved. We're just approving the new changes, the update.
So it sounds like you have not had experience with voting on each issue separately.
Not specifically,
Okay.
because it
So-
hasn't really come up as a need to do it that way. Not
Okay.
that we couldn't, but we don't typically have that need. Like I said, there
Okay.
is a difference between this type of format and a small local unit, PTA, that's not has as many members as we do. But again, my experience would tell me that I think the majority of people don't want to know every little nitty gritty thing about all of this. They just want to know what are you recommending the changes to be,
Mhm. Yeah.
And if we overwhelm them and say, here, it's a lump sum, presentation, I think some of them might just tune it out, and they're either going to be voting okay and not really knowing what they're okaying, or they're just going to say, as Keith said, I'm not even going to touch this one. I'm going to skip this question because I have the time to sit here and read it all,
Okay.
So,
One of the considerations in a item by item vote, approve or disapprove each item as you go through, is it's going to that would make a complex or at least thick voting package. Being able to identify, to check off each item, yes or no, I don't. That's not a reason to not consider this. That's just an observation. That's significantly different than we've used before in our voting.
is there a way to group similar changes so that it's not each individual maybe, but like a section, if there were multiple changes within a section, could we present it that way versus, these are all related?
Yeah. Well, to a certain extent, we've already done that. The status, the spreadsheet or Excel status, that actually groups what I'll call similar topics. The input or the requirement, request, whatever, as it came down from the work group, was a section by section in the bylaws what to consider. And what we did is take those sections and to a degree group some of them together as a similar topic. So we've already done some of that grouping together. Now, could there be more done than what's on the Excel spreadsheet status? More, adding more together under one heading, that's possible. I haven't given that a lot of serious consideration beyond the initial grouping together that was accomplished.
So my purpose for bringing that up was simply to your question about format. that my recommendation would be that whatever format we come up with to submit these to the board be written in such a way that the language in there that we provide could be used standalone if necessary for each issue in the event that that's eventually how it becomes. In other words, if the board decides to do it that way, to present them individually for individual vote, that they then don't come back to us and say, well, we're going to need a little bit more information about these that we can then put in the voting package. So just to your question about format, whatever explanation that we provide about the background, what we thought about, and why we come up with the recommendation, I'm just saying I'm recommending that we do that in such a way that it's reusable in the event that that's the path they take.
Okay. Well, I think if I'm misunderstanding or the approaches being considered would be basically what we've already done. Now, I don't mean literally the same information, but what we have done is laid out a specific bylaws change proposal with some information as to background, why, and what the background of the change is, why it's perceived to be necessary, and this is what it does. We've already done that kind of thing for just about all of the proposals. I'm not suggesting that what we have done is finished product. No.
I agree with you, Jim. The only thing I would say is that the language that we use in that feedback is intended for the board. And the board already has a basic background and understanding of some of these issues. We might write it a little bit differently if the intended audience of that language was going to be the membership.
Right.
I guess is my point.
Yeah. Okay, I don't know that we need to try to finalize this today. We've got a basic proposal. I think that this is expressed by Keith. And look, I know we're not ready to start doing this today, and trying to figure out who's going to do what and what part of it and how. Let's hold this discussion. Let's hold the thoughts that we have today, and we'll go further toward finalizing that kind of approach at our next meeting, or at least a near-term future meeting. Let's if it's okay, let's proceed on that manner. Okay. Now let's get down to it's not kind of the heart of the meeting. Let me turn around here and try to find some of my material. I want to try to catch up to what Steve has given us some input on. And excuse me while I try to get some stuff in front of me that I think I need to be able to handle. Reference is made to section 502. Let me turn my bylaws to 502. Josh, I don't know, you got the bylaws handy?
Of course.
Section 502. No, not that. That's the summary. This is the bylaws themselves. We're close. A little further down. There we go. I know it says in the first section of 502A, strike out all after the word hold. Where is hold at?
I'm sorry, I think it should be held. If you look at
Oh, okay.
502A under eligibility, go to the second line.
Okay.
And then the next to last word is held. I'm not
Okay.
a good typist.
I feel your pain. Sir, and add the following sentence, notwithstanding the provision in Article 3, Section 301C, we can go back there of these bylaws. Any candidate for the board shall have paid the annual charge, including assessed interest by the association by June 1st of the year of election. by the date of the eligible candidate, or by the date of the date list of eligible candidates submitted by the secretary. Okay, I pretty well follow that. I'm gonna make a comment. Let me make my own comment here. And what we're talking about is the charge item that's section 502A, and in the email it's entitled candidate verification and eligibility to vote per section 301C. And Colette goes on to describe some difficulties that have been had in the past regarding this provision. I'm not sure if, looking here again about the charge itself, whether it made reference to litigation that occurred several years ago involving the 35-day provision. And that the 35-day provision appears to be at the heart of the problem, or at the heart of the confusion.
Are you? So there's three issues. I think that's the second issue, the 502 alpha, or with 502 alpha. But the first issue with 502 alpha is the definition of owner of record. Well,
that's a separate. Let's hold that for a separate discussion. Let's stick with the voting eligibility issue.
Okay.
Yes, go ahead.
Jim, if I only work from the charging document that we got through you from Colette. So the way I read it was there was a conflict between the two provisions, between 301C and 501A. And so it appeared that the way I was reading it was that, if I'm wrong, please tell me, but Colette's recommendation at least was that we should amend 501 and not touch 301C, which is what I attempted to do. And all I was saying was that the date certain, if you will, is the submission of the list of eligible candidates, which I believe is June 1st, by the secretary. And the only reason I included the language at the very end, where it says including any assessed interest by June 1 of the year of the election, or by the date the list of eligible candidates is submitted by the secretary, is only because I was attempting to be pandemic sensitive and assume that in some situations that June 1 date might slide. And so I just was covering all bases.
Okay.
My thought was that sort of dealt with the question at hand, but if I'm open to any thoughts. And if this doesn't do it, we can try something else. That's fine also.
Colette, my understanding of the concern here is the attempt to apply the 35-day voting rights provision to the eligibility to be a candidate. That a prior candidate applicant did in fact contend and did in fact go to court. His case didn't go anywhere, but went to court claiming that he had 35 days to be able to bring his assessment into compliance in order to be a candidate, to qualify as a candidate. That's not
exactly how it went. The
Oh,
35
okay.
days.
How
May I
did it
explain?
go? How did it go then?
Okay, so the 35 days prior to the voting deadline occurs sometime late in July. Okay, so the voting deadline is usually the first week of August, give or take. And so you count back 35 days before that, you're into mid or late July. Yet the secretary has to verify the eligibility of the candidate to run and have their name on the ballot by May 15th. And so the argument that this person made was that, okay, by May 15th, his assessment was not up to date, but per 301C, he has until mid-July to demonstrate his eligibility to vote. And so that puts the secretary in a dilemma because he or she has no crystal ball to know what's going to happen, 30 days hence, sometime in July. The secretary has to make her decision on the 15th of May. And so that was the argument that we put to the court. And it was really a bad faith case. The court wasn't going to tell us how to do our business. The court was determining that the failure to verify this candidate did not represent bad faith. It was a good faith effort to reconcile these differences in timing between 301C and 502A. And so, this charging document requests you guys to make a recommendation for some change in 502A that may make it unnecessary for this effort to be decided by a court again. And I think what this email has done, the email from Steve, is an attempt to do that, but the June 1 date puts the squeeze on the secretary to make the decision, communicate it to the candidate, communicate it to the elections committee in 24 hours, in one 24-hour period. So if a change is going to be made, such as the one that's being recommended by Steve here in this email, I would suggest that the by date be May 15th, because that's the date that the bylaws say that the decision by the secretary needs to be made. And I think that of course, all of this is going to be reviewed by council before we send it to referendum. But I think that will, what Steve is proposing with that date change will resolve the conflict and lift the squeeze, so to speak, off of the secretary.
What's the squeeze on the secretary?
The time squeeze. That
What time squeeze are you referring to?
If the candidate has, or the applicant has, by June 1 to pay their assessment, June 1 is the date that the list of eligible candidates per bylaws must be given to the elections committee. So on that day, the secretary needs to be available to verify that the payment has been made, cleared the bank, and to communicate to the candidate and the elections committee that this candidate is eligible. And having sat in that seat, it's not always possible for you to get that done on June 1st. So that's where you really have 2 weeks, May 15th, between May 15th and June 1st, to get your ducks in a row, get all the decisions made, communicate the decision to the people that it needs to be communicated to.
Okay, but you're not reading. You're not.
I'm sorry. If I may, just by explanation, the only reason I have no problem with whichever date you want to choose. The only reason I did not pick the May 15th date was because I sort of envisioned that period between May 15th and June 1 as the period by which the secretary could inform the candidate, your assessment and any accumulated interest hasn't been paid. You need to do it by this date, or I can't submit your name to the committee. That's okay. The only reason I picked June 1, but I have no problem.
Colette, what is the reason that the May 15th as of date cannot be met? You're ignoring section D. The secretary shall verify that the association records as of the 15th, support each candidate's eligibility, and then submit the list of eligible candidates by June 1st. Why
So the
cannot
secretary,
May 15th?
okay, so if the candidate has until June 1st to satisfy the payment of their assessment requirement, the secretary can't say on May 15th that that requirement has been met.
But
Okay,
where does it say now that you have until June 1st to pay?
it doesn't say
talking about
anyplace.
right
I'm just
now. We're
saying
talking
that
about
this is what Steve is proposing.
now. Okay, I understand. I
Okay.
understand. And if I was to make a proposal, I would take this May 15th out and make it May 1st eligibility date, not May 15th.
Yeah,
I see
whatever. I
what's
mean,
the
the date
reason
is
for May
immaterial.
15th?
Just that
The
I'm
date
just pointing
that-
out that the secretary needs to make a decision May 15th, that as of May 15th, these requirements have been satisfied. And if they haven't been satisfied, it's not fair to the other candidates to give them till June 1st to satisfy them, or till
Well, I agree
sometime in
with
July.
that. I agree with that entirely. The cutoff date is May 15th. The secretary then starts on May 15th with the records to verify eligibility and has until the June 1st to do that. Is there some reason why 2 weeks is insufficient to do that? We've got to postpone the verification that this candidate or aspiring candidate has done what they're supposed to do, give them a full 30 days past the date of due to begin with? Why? That makes no sense.
Well, I guess what I'm kind of stuck on is that the resolution says that as of May 15th, the individual has met the requirements to be a candidate. And so, my thought is that as of May 15th, all the requirements must be met. Otherwise,
Colette, that's exactly what the bylaws say.
right. But this candidate, Hill, was arguing that 301C actually gives another month and a half for the candidate to become eligible to vote. And so I can't, as secretary, know on May 15th if they're eligible to vote. If they haven't paid their assessment yet, how am I to know that by mid-July they're going to be eligible to vote? And so, and that was the issue, that issue in this case.
Okay,
How
well,
can the secretary
Keith?
know something in the future when they have to make a decision May 15th or,
Can we
Keith-
let Keith speak?
yes.
So we, as a committee, have actually discussed this in the past. We weren't tasked with it, but as part of looking at 301, I specifically questioned 301C and the 35-day deadline because I didn't understand. It just seemed arbitrary to me. And Jim, as I recall, your explanation for that 35-day deadline was because a certain level of review needed to be done prior to mailing out the ballots. So that gave the people mailing out the ballots an opportunity to review the records to see who was paid up and who wasn't paid up. And my comment to that at that time was that was prior to us automating our financial records and automating our systems. And it would seem to me that today, using the technology that we have available, finding out who's paid up is the press of a button, and we wouldn't need 35 days anymore. And so we didn't do anything with that because we weren't specifically tasked about it. But I think that the 35-day requirement in 301C is problematic. And I think that was to Colette's point about causing confusion relative to these other dates, is this 35-day prior requirement. So it seems to me like we should be looking at that and whether or not that's still appropriate, whether it's still needed. Because if we really, no kidding, need 35 days prior to the voting deadline, then it seems to me everything else needs to line up to that.
Okay, give me about a couple of minutes here on this 35-day provision. What is being missed is that there is a difference between eligibility. In this case, we're talking about eligibility of a member to in some manner participate in the governance of the association. The eligibility to be a candidate for the board of directors, the eligibility to be a member of a committee, the eligibility to count as a member of the quorum in a members meeting, the eligibility to have your signatures count on a petition. Eligibility to vote is a qualification to be able to participate in that part of the governance of the association. The 35-day provision is a voting rights provision. You cannot vote when there's going to be a vote unless 35 days before the counting of the ballots for whatever it is, referendum or directors, you have not paid your assessment. Also included in that is you have not had your vote suspended by the board of directors. There is a failure to recognize that there is a difference between eligibility to be able to do something and your right to cast a ballot in an upcoming vote. That is where the failure breaks down in this situation. Now, in the past bylaws, there was a defined term called member in good standing. And what it used to say is that you had to be a member in good standing to be a candidate for the directors. And that included the payment of the assessment. That included not being, having your vote suspended. It also included a whole bunch of other stuff that people I heard joke about saying, well, if you got a jaywalking ticket, you weren't going to be a member in good standing. So the people who drafted the 2008 changes wanted to limit that kind of consideration and limit it solely to the payment of the annual charge as well as the restriction or suspension of vote. Well, what they did in 301C is mix in those two requirements with a voting rights requirement, and they are not the same thing. Eligibility and voting rights are not the same thing. My personal view is to take 502A and go back to what it used to say. It used to say, and I'm not going to call up the old bylaws anymore, but it used to say you had to be a member in good standing. You couldn't, and you couldn't be at the end of the second term, 2 consecutive terms, you had to be an owner of record. To simply reinsert the equivalent of member in good standing in there. Put in there that no member may be a candidate for election if there's coming up incumbent for after 2 terms. Put in there, you got to have paid your annual charge. Put in there, you can't have had your vote suspended. Period. Go away. That's it. Effectively going back to the member in good standing provision. And I, honest to God, thought about suggesting that while I was looking at these charges yesterday. And I said, no, wait a minute. Don't do that. Don't go back into history like that. Just put in there what it is. You got to pay your charge. You can't have your vote suspended. Nothing refers to 35 days. That was a specious argument by the candidate or proposed candidate that didn't go anywhere, should never have gone anywhere, and should be looked at as that way. But here we are talking about having to change the bylaws. Fine.
Yeah, unfortunately, if I could just insert, Jim, I agree with you. That was a specious argument, but it cost the association money to litigate it. And if we did what you're proposing, write 502 properly, so we don't have any conflicts with 301C or any other part of our book of resolutions, we will avoid finding ourselves in that situation in the future. Hopefully.
There is no effective counter argument to that. I certainly understand that. Now I'll write out my own proposal and circulate it, and we can consider it when the time comes at the next meeting, or whenever we have it in the next meeting. We've got one proposal here from Steve. I'll add my own to it.
Should we, so I agree with what was just said. Along with that, in paragraph D, 502D, should we remove as of May 15th so that it just says verify the association's records support each candidate's eligibility?
Well, I think we have, I frankly do not understand why we have May 15th in there.
Right. That's why I'm wondering if we should just remove that.
Well, but I think you have to have a date of some kind. You can't just leave it open because somebody said, well, it didn't say I have to pay my assessment.
Is that not covered under your
Well, yeah,
member of good standing?
I agree. I agree.
Just a thought.
Okay, I guess I would comment as a former secretary and observing the actions of secretaries since then. I think a date by which the process is done is a good thing because it holds us accountable to getting it done and having the list prepared and ready to get to the elections committee. Now, the secretary works very closely with the elections committee, and the elections committee invariably tries to push for the list earlier than June 1st, particularly now that we have with mail-in ballots. You know, if we're going to continue with mail-in balloting, and the mail as slow as it is, that has been a concern of the elections committee, that they want to get the ballots in the hands of the voters earlier rather than later. This year, there were over 300 ballots that came in after the due date. You know, and presumably that had to do with the slowness of the U.S. mail service and the peculiarity of Ocean Pines mail that goes to Baltimore before it comes here. Even if you mail it here, it goes to Baltimore before it comes back here. So I don't, as a former secretary, I don't see a problem with either of those dates staying the way they are, because it gives ample time to clear up any confusion. It also provides the option of getting the ballots out more quickly if there's a reason to do that.
Would
Colette, may I ask you a question? I'm just curious. As a former secretary, is it done, or is it possible, whichever term you want to use, for the secretary to communicate with a particular candidate whose, assessment hasn't been paid during that time frame between May 15th and June 1, so that the candidate is then informed, quite confidentially, if you will, informed that he or she has 2 weeks to get the check in, and then you'll be on the list. If you don't get it in 2 weeks, you're not going to be on the list.
Yes, and
can that be done?
Yes, Steve, that has been done, and it is done. That's another reason for that kind of 2-week time frame. If when I was secretary, I began this process on the 15th of May. That gave me theoretically 2 weeks to resolve those kinds of issues. And, in the case of a piece of property owned by an LLC, we had to research who's the owner of the LLC. In the case of a trust in this past election, we needed time to determine who's the owner of the trust. So if you wait till the last minute, till, May 29th or 30th, you're not going to have time to do that. But if the deadline is May 15th to at least begin that process, it gives you time to do that legwork and communicate with as I did, with the member whose assessment was not paid up. He said, okay, but I am an owner of this, there's this other piece of property owned by an LLC that I'm a principal in. Then I had to research that. Is he a principal in the LLC? So it ended up being, pretty time consuming and lengthy. That's a little bit easier when you're retired. You have time to devote to that. If you are a working member of the board, which I think is desirable to have diversity on the board, that's a lot harder. So that 2 weeks is very welcome from the point.
Keith?
So Colette, everything you just said makes perfect sense to me, but I would argue that's not what D says. I would argue that what D says is that the records as of May 15th, in other words, you got to put a pin in it. On May 15th, you put a pin in it, according to the way I read this.
Yes.
And if they're not paid up on May 15th, it doesn't matter if they get paid up by June 1st.
Right.
The way I read
that is
D,
what it says.
So in order to support the process that you just laid out, which I think is appropriate, maybe what D should say is, beginning May 15th, the secretary shall verify that the association records support each candidate's eligibility, blah, blah, blah. In other words, we codify the requirement that the review process start May 15th, but we're not saying that the records as of May 15th have to support the eligibility. Because it seems to me that if you call the individual, you call the candidate and they say, yep, sorry about that, a new check is resubmitted and it's resolved, let's say May 20th. And so now, prior to the June 1st deadline, they're eligible. The way I read it, legally, they're still not eligible because they weren't eligible on May 15th.
Right.
Okay, so let me make another comment. How much burden do we want to place on the shoulders of the secretary and the association staff to find a reason to make someone eligible? I think about this the same way I think about when I applied for my psychology license. I had to have all my ducks in a row, or the application was rejected. Nobody called me up and said, hey, I don't have your transcript from Marquette University, or hey, I don't have, the scores from your national licensing exam. You forgot to put that in there. The burden is on the applicant. Same thing when you get your driver's license, when you get your electrician's license, any license, anything that you are applying to do or become, the burden is on you to have your ducks in a row when you submit that application. And the application reads that way now. In 2018, when this litigation occurred, the application did not read that way. And so we changed that because the belief is that expending staff time, attorney time, which we're paying for by the hour, and association officer time, that's an undue burden to place on them when the applicant is the one that is claiming eligibility. The eligibility requirements are plainly stated in our governing documents. They're plainly stated on the application form that the applicant signs. The burden is on them to get their ducks in a row and submit their application and any required supporting documents that support their claim of eligibility as a candidate.
I completely agree with all of that. And I apologize if I misunderstood earlier. I thought what you were saying was once the secretary starts the validation process and they see that according to the record, for example, they hadn't paid their assessment, that you could contact them and give them an opportunity to make that payment. I thought, in
Well,
other
you
words,
can. There's nothing in our governing documents that prohibits that.
Oh, wait a minute. There
well,
absolutely.
that's my point. This Delta
Absolutely.
prohibits that.
You cannot give them a 15-day grace period. Just simply isn't there.
Well, if I can, it seems to me there's sort of one of two ways to proceed, and I certainly don't disagree with anything that Colette said. It makes perfectly good sense. My view would be either, if you wanted to go with the language that I sent around by email, then change the date that I had there from June 1 to May 15. That makes it consistent with sub D. The other way to do it would be to strike the May 15th date out of sub D, which would give the secretary the 2 weeks period to say to the candidate, look, I can do it confidentially. You have not paid your assessment and any accrued interest. You need to do that before I submit this list on June 1. It seems to me either one is workable, and would therefore remove the conflict with the Article 3 language. But either one would fix it, notwithstanding Jim's suggestion about a member in good standing, which I'm not rejecting. I'm just putting that aside for now. But either fix would meet the need, because I think if it was, I don't know who's speaking. I'm assuming that was Keith. Makes a good point about D. D and A would now be in conflict, and so either change the date on the my recommendation or remove May 15th out of D. Either one would work.
Okay,
Okay, may I speak? May I respond to that? I guess the concern that I have actually is that if the secretary has from May 15th to June 1st, that kind of a grace period, then, is it up to the discretion of the secretary to inform the candidate that they have an eligibility problem, or are they required to? I kind of go back to my original statement that there shouldn't be a grace period. As of May 15th, the ducks should either be in a row or not in a row. If they're not, the application is not rejected, but the candidate is not verified because there's insufficient evidence to support their claim of eligibility to be a candidate. If you give that discretion to the secretary, the way Ocean Pines politics work, there will be a claim that the association secretary improperly used their discretion to unfairly fail to give a grace period to an applicant. I think just like with anything else you apply for, the due date is the due date. The ducks need to be in a row. The documents need to be presented, and the burden is on the applicant to make sure, because they have months to find out, to reach out to the search committee, the elections committee, and do their own homework on what is required, and make sure that if they have any questions about what the requirements are, they get the answers. They take responsibility for making sure that they satisfy those requirements, that the burden is not on us.
I'm sorry, I didn't mean to interrupt.
Sorry.
No, I take everything you say to heart. I think that's true. Candidly, I've only lived in the Pines a little bit over a year, and my prior experience with homeowners association was, I could pull somebody aside and say something to them. But I don't disagree with what you're saying, and if as long as all of the information that the candidate needs is clear, then it would make sense to go with the May 15th date. I understand everything you're saying. I think it's correct. I was just creating some sort of cushion so that you avoid problems, but I understand exactly. I have no problem with changing the date. I'm not wedded to the date. I just did it because I was trying to create a cushion for everybody.
Okay, just an observation. We started out addressing a 35-day provision, and now we've extended ourselves into a rather potentially significant revision to the eligibility provisions themselves, or the manner in which the eligibility is determined and the length of time eligibility can be established. I don't have any problem with that, but the eligibility, I'll go back to the member in good standing days. You have to read the bylaws provision, but as of the submission of a candidate's application, and that's not really what supposedly happened in pre-2008, but as of that submission, the candidate was expected to be in good standing, meaning that he met all of the requirements. So I really would have difficulty going down a path that somehow extended this May 15th cutoff to some period of time, and in particular an advisory to any kind of an expected or required advisory that you don't meet the requirements, but you can do this to meet them. That's a real significant change, in my opinion, in the bylaws if we were to pursue that.
I'd like to just add that Mike,
Laura, go ahead.
I would just like to add that I feel that in however it all ends up, whatever wording we're using, that we eliminate or really make an attempt to limit any position, especially the secretary, use of discretion. Because anytime you leave something so open-ended or subjective to that person, one person making the decision, you're going to open up a can of worms. Because the person who's the secretary, because if we're not going to do, if we don't overhaul and keep updating bylaws every year, you could have a potential secretary down the line whose personal discretion is different than the one that we're talking about currently. You know what I mean? And somebody else then could say, well, I didn't agree with their decision on when to make us eligible, or, so I don't think we need to, in order to protect all of our board members and protect those who are in the decision-making process, we should limit the having too long of a time frame, because like what Colette mentioned earlier, though, is the secretary required to say to a candidate, there is no record on hand that you paid your dues, or is it a courtesy comment to say, hey, before I make you ineligible, you've got X amount of time to get it paid? If that candidate is really serious about being a candidate, in my mind, I would think I would have had all of that done early. And if I don't normally pay my dues until June 1st, but I know I'm planning in February that I thought this year I'm going to run, wouldn't you make provisions to make sure you've paid it well in advance, like before you turn in your application, so that there would be no reason for them to find you ineligible? So I do think a lot of the burden should be on the actual candidate for responsibility, because that's going to show us the good faith of how they're going to be as if they were to become a director. If they can't get their ducks in a row and make sure that when they apply and want to be considered a candidate, that it's just a fly by the night kind of thing, then is that how they're going to conduct business as a director? But I also think it's more of a protection to that secretary from what has happened now, is that different perspectives cause different decision making, and there should be some consistency in that. So we need to make sure we're using language that doesn't give too much freedom that way, I think, because what I think might be right, you all might think is not. But if I'm in that position and I use my ability to make the decision to determine someone's eligibility, is that going to cause a problem and have litigation end up happening again? We don't want to keep that possibility open all the time, Keith?
So I think we all actually agree here. I think we're just saying the same thing in slightly different ways. So to me, this kind of brings it all back around to what Colette originally sent, which is the perceived disconnect between the 35-day number that's in 301 Charlie and the deadline that's in 502. So do we agree that taking Steve's recommendation and changing the date to June 1 solves that?
Well, let me just suggest, again, notwithstanding Jim's desire to address the member in good standing issue, which I just want to push that aside for a second. I think Colette is correct. So I would suggest to you that all we have to do is take my language, take out the June 1 date and put it in May 15. And that then removes the inconsistency in 502A and D and resolves the conflict between 301C and 502A. So if you want to change the date to May 15th, you're putting the onus on the candidate to get his ducks in a row. You're giving the secretary less flexibility. You're removing the conflict between the two separate sections, and you're not creating any inconsistency within 502 at all. So I have no problem if you want to change the date on that language from June 1 to May 15, and we can come back and visit that as well as Jim's thought on member in good standing at the appropriate time. But I have no problem changing the date. I think we resolved the problem.
I support May 15th.
Okay, I agree with Steve. We can exchange our information and we come back to it either the next meeting, whatever. I think we pretty well run this for the right at this point in time. Where I'm cognizant of Keith having a hard stop at 3 o'clock, and I think we want to make sure that we all have an opportunity to continue on with the remaining two new addition items in the time we have left, so that each of us can have some input before Keith has to leave. So let's for whomever wishes to make input on how to address this item, let's go ahead and exchange the ideas and be able to talk about it next time. Keith, go ahead.
Okay. So I actually saw what Steve wrote, and I don't disagree with it, but we're talking about the owner of record issues. Is that correct?
Not yet, but we can move on to it right now.
Oh, okay. I'm sorry.
We were talking about the 30-day eligibility issue, but I think we can close that off. Let's go to the owner of record. That's fine.
So on the owner of record issue, I thought about this a lot, and it seems to me that as our options as a committee we have two options to recommend to the board. One option involves language that's going to have to come from real estate lawyers, right? Because it's going to have to be something that stands up in a court of law, and that's not language we can come up with. The other option is to go simple and direct, meaning that we would simply state that the name of any candidate applying to run for the board must appear on the deed of real property located in the Ocean Pines subdivision on the first day, blah, 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 blah. In other words, we just simply state your name's got to be on the deed, period. Because kind of back to what Colette was saying earlier, anything other than that is a rabbit hole. It requires research, it requires effort, it requires a certain amount of legal savvy, it potentially requires the involvement of lawyers, because it's anything other than that is it's an ownership, by association, right? And so then the question is, do they need to own 50% of it? How much of an ownership stake? Is it a fifth? Is it a tenth? Is it an LLC that controls it? How many people are legitimate partners of the LLC. I mean, it's just a rabbit hole, right? And if the board believes that that's the appropriate way to go, because they don't want to limit somebody's ability to run for the board, then that's going to have to go to the lawyers, because that's over our head. But if we go the opposite way and we say your name's got to be on the deed, period, then it makes it super simple. It easily stands up on a court of law, because you don't need a definition for that. Either the name's on the deed or it's not. The only downside to that is it potentially limits some candidates from applying who own their homes as part of an association, as part of a LLC, as part of a trust, et cetera, et cetera. So that's my 2 cents.
Is there, and I have not looked at an application, is there a spot on there where a candidate would have to disclose right from the get-go that they have one of those other scenarios where they're not a straight name on a deed, and that, to give the heads up that they might be because of a trust or an LLC, or you know what I mean, that they need to disclose that up front, so that if if we're going to open it up and make it so that anyone is, has the potential to run, that okay, this one's going to be one we're going to have to research a little bit more deeper to make sure that what they're stating is correct. You know what I mean? I don't know how much
Laura, I can answer that question.
Okay.
The application form, as states presently, that if the Ocean Pines records do not show you as an owner of record, please submit supporting documentation that does. And which turned out not to be a very good way of wording it. I believe in the future we'll change that to a requirement rather than a request, and maybe state it more clearly that in the case of an LLC or a trust, supporting documentation of ownership would be required. But Keith raises a good point, and that is, what percent ownership then would we be seeking?
Right.
The other question I have, I don't know the answer to this, and I should know it because I'm married and my husband and I own our property together. Are both parties in a marriage always named in the deed?
Mm-hmm.
Depends.
Or not?
Yes.
It
Yes.
depends.
Yes. Okay.
Some owners of property, of real
Money.
property, are listed simply as, let's say, the husband or just the wife, depending upon how the contract is cut and how the mortgage is financed and everything else. And so that part that changes from individual to individual. If I can go back, I remember sitting in the board meeting where some of this came up in this year, and as I recall, and I'm certainly not pointing fingers at anyone, but as I recall the initial explanation by the then secretary, it was that she consulted the membership list of the association, and that listed the gentleman in question, Mr. Farr, as being a member in good, I'm sorry, not a member in good standing, but being a resident, and therefore she approved his application. It was only upon further review, either at the county clerk's office, or you could have used Maryland Department of Taxation and Assessment to determine who the actual owner was, which I believe was and is a trust, and he was not a trustee of the trust. So there may be to insert a requirement that where you have an association of some type, LLC, trustee, whatever other group might own the property itself, I think it's reasonable to pursue that. I don't have an argument with that, but I'm not sure you could get that into 502A and address the question at hand. it seems to me is something that the elections committee would need to address if they change their form and their application. And it may be that the language has to be much clearer. But where you can determine who the owner is should rest with the official records. And that, to me, that would either be Maryland Department of Assessments and Taxation or the county clerk's office. So that's why I chose that language.
I kind of struggle to make a comment here. I think we talk about defining the owner of record. What we're really talking about is defining who can be a member of the board of directors.
Right.
And
right.
that is a very large question, or one that requires some real thinking by people who know what they're talking about. Now, number one. Number two, that's what this whole thing about is in the current litigation. And for us to be sitting here and giving it a whole heck of a lot of thought until this litigation is completed, it's not very productive as far as I'm concerned. But what we're really talking about here is who can be a member of the board of directors, and to a significant extent is how far into what is in the land records in Snow Hill, Worcester County land records in Snow Hill, how far are you going to go into that, and how deep are you going to dig into that to find what relationship to Ocean Pines is satisfactory to you for the individual to be a member of the board of directors. I have difficulty expressing it any other way than that. If we get too far away from a simple approach, then we're in a hopeless situation of questioning and potential controversy and litigation.
There will always be someone who will question. Yeah.
And Jim, if I can, I think that's true, except for the fact that if you just take, I mean, how do I say this? The issue of who is the owner of record, the question is, what record are you going to look at? And the problem that cropped up in this election was that, as I understand her own explanation, she looked at the wrong record, for lack of a better term. Again, I'm not pointing fingers. I understand that's what happened.
We shouldn't. I feel like we should leave the current litigation out of this discussion.
That's fine.
And talk in general terms, so that we don't cross any lines there.
Okay, my point is simply that the plain language would be who the owner is. Well, how do you determine who the owner is? You go to the record. And that being said, it's pretty easy to get online with the Maryland Department of Assessment and Taxation and pull that up. But you're right, if the basic concern is we really shouldn't do much until we see how this case resolves itself. That part is true, but I was only dealing with what was sent to us today. So,
well, I agree with what Jim said in general, which is that this is a big question. Mm-hmm. It's a big question, and maybe the question is not maybe are you an owner? Maybe that's actually not the question. But if that is the question, then that leads to another question. Well, how much of an owner are you? Are you 100%? Are you 50%? Are you a fifth? Are you a 15th? And are we going to make a decision? Are we going to draw a line in the sand that says you got to be at least 1/5 of an owner before we think you have enough of a financial stake to be a part of our board, make these decisions? It's a big issue. Mm-hmm. So, to Jim's point, it's a big question that's going to require some thought, because maybe at the end of the day, the answer is not that you're an owner. maybe the answer is, for example, you've lived in Ocean Pines more than X number of years. You know, we've talked before about some of these permanent, essentially permanent long-term renters that we have that have lived here most of their lives. We've talked before about the proxy vote and how we've already got a process in the bylaws for essentially giving our vote to somebody else via proxy. And, you know, we've just very casually discussed what that could potentially mean for committees and, you know, additional involvement in the neighborhood. I think there's just all sorts of avenues here that can be looked at to not only solve this issue, but to maybe solve some other concerns that we've talked about in the past. So I don't think I don't think we should assume that right now the task is simply to define owner of record. Over.
Let's move on to the next item. Let me make just a final comment on owner of record. If it's just a simple identification of what owner of record means, you don't have to go any further than the declarations of restrictions for each section. If you start out at the very beginning of the declarations in each section, the preamble statements, you see that the basis for the subdivision of Ocean Pines, the basis for the individual sections, and the basis for the lots within the sections is all the land records of Worcester County. And that's not going to answer the issue before us. The issue before us is who could be a member of the board of directors. And I think you can only look at, I appreciate what Laura said about the current litigation, but you can only look at what's being contended to be qualified to be a candidate or to be a member of the board of directors, that individual, and I'll compare, and I know you shouldn't personalize these kind of things, but you look at my deed, it's my wife and I, tenants by the entireties. What's the gulf between the two? That encompasses what is incorporated in trying to answer this question. And I apologize for getting off on a tangent here. So let's move on to the issue of cause. The issue, and I know we're really running out of time here for Keith, and I also want to acknowledge that Bob has been with us here. I see him laughing so he can hear us. Bob, I haven't meant to ignore you, but I hope you have had any opportunity to comment that you had the opportunity, but I'm sorry to fail to recognize you earlier than now. Anyway, the third item is to further define cause for removal of a director. And my question for the committee is, okay, how do we go about doing such a thing? How do we, what do we use? What process do we use? Resources do we use? What's our thinking on how to approach this particular item? Keith, go ahead.
So since I got to go in a little bit, I have a question and a comment. So my question is, does the Maryland HOA Act, and I know I have a copy of it somewhere, I should have read it, does it provide guidance or restrictions on removal of a director? I don't recall. Maybe it does. So that's just a question. Certainly we should know that before coming to any conclusion on this, number one. But number two, assuming that it doesn't, meaning that it's completely up to us as an association why we would remove a director, I kind of have the same answer for this that I have for the other thing. That instead of trying to define cause, which to me, again, is a legal rabbit hole, my recommendation would be to remove it. In other words, a director may be removed by a 2/3 vote of the entire board, blah, blah, blah. We don't say for cause. In other words, we can remove that they can be removed either by referendum of the people for whatever reason, or they can be removed by vote of the board for whatever reason. Assuming again that Maryland HOA law does not prohibit us from doing otherwise, we simply remove that. That would be my 2 cents before I got to take off here on this issue.
Okay. Any other comments? I have a comment or a question for Colette.
But if I just,
Go ahead, Steve, go ahead.
I think you'd have to get advice from counsel. But I think if you just remove, I admit it's undefined, but if you strike cause out, then I think the aggrieved party might have reason to argue, it gets no equal protection at all. In other words, anything could be a reason to remove somebody from office, and there's no definition as to what that would be. And I don't know that, it may be that using the term removal for cause is a rabbit hole, taking it out may be an even deeper rabbit hole, and I would suggest that's something you may want to talk to counsel about. But I think it's tough to come up with some sort of shopping list, but it's almost seemed to be what's being suggested here. That's as far as I've gotten with it.
Colette, are you with us here?
Yes. Mhm.
There have been, of course, relatively recent incidents with regard to board member removal. Has the board received any kind of guidance in these kinds of situations with regard to the meaning of cause?
Well, when we had BO8 was used as a basis for determining cause. When we rescinded that, and it was rescinded not because the Code of Ethics and Conduct was not considered desirable, but it was rescinded because the resolution had very complicated and arcane attempt to provide equal protection. And so there was some, belief that we just fell way short of that. And there was a difference of opinion about, equal protection, I guess, without using, those particular words were not used, but it was kind of the spirit of what Keith was talking about, that we need to have some standard that process that could be consistently applied. And people were of two minds. One was the bylaws state 2/3 vote. That's simple process. Cause could be defined by a violation of a code of ethics or conduct. And our council has not given the board advice on this per se, but in my personal conversations with our corporate counsel, he has indicated that he believes that it would be desirable to have a code of ethics and conduct as a basis for determining cause. But that was an informal conversation. I would say that should be considered off the record, so to speak, because he had not studied this and, of course, done the research required to provide a defensible and rational legal argument one way or the other.
Well, the bylaws do, in fact, provide for a cause definition in resolution. That may not be a very good recitation of what the intent is, but there is that reference to resolution identification of cause. I'm a little bit uncertain about in the history of the association. Have we not considered removal for cause? Keith?
I got to go, Jim.
Okay.
You still have a quorum, so you're still good, right?
I'm good. We're good.
Okay. All right. I'm very sorry, but I got to go.
Okay.
We'll let you know when the next meeting is.
Okay.
Yeah.
Thank you.
All right. All right.
Jim,
Anyway,
I think you know the history of Ocean Pines better than anybody here. And, I'm not aware of any specific discussion of the meaning of cause by the board, but I do know that there have been fewer than, I think, maybe 3, maybe 4 attempts to remove a director for cause. And the absence of a clear definition has been viewed as troublesome.
Okay,
So-
let me just comment on that. The reason, in part, the reason why I bring it up. Yes, there is in the association records a discussion of cause that goes back many years by the then association council. I have a copy of it. That doesn't mean I was privy to a comment, the document at the time. No, but I do have a copy of an extended discussion of cause, and I I think we're way out of the element of this committee to be able to define cause. The attorney had a specific reason for addressing the question of cause at the time, and he went into a thorough discussion. I'm not going to try to summarize, but it deals with performance, willful, negligible, unsatisfactory performance. Those are, kind of summary comment words in there. Do I think that's a very valuable document? But where can this committee go with that kind of thing, or propose that kind of thing? We got to consider that. I don't know. I really don't. I think that the association council is the one that has got to advise the board what it's trying to do if it's going to remove somebody for cause. As far as a code of ethics, I don't see this committee being qualified to we can say, sure, you should have one. That makes kind of sense to me. When I live in the park, we have one in the park. The board of directors and the committee members have to sign it every year. It's a long list of ethical considerations, if I can put it that way. And it's signed. 500 some odd member park, and we got this kind of a detailed code. And we got the 8,500 member, 12, 13, $14 million a year budget. Ocean Pines we can't get something together that lives. The second time in 15 years or so died here a couple of years ago, or in the last year or so. What's this committee going to do about that? I don't know. We got a council, we got a lawyer's office that's got a human resources section in it that we really ought to be looking to for this kind of thing.
So would the lawyer be able to give us at least directions on, from a court perspective, to say what would be the better scenario? Should we have it cause defined and all of that to prevent potential litigation and all of that? Like, I feel like what could potentially cause somebody to want to go through all of that because we left a word out or something? Is that, a bad judgment on our part? You know what I mean? That from their experience, what should we have in there? How detailed should it be to prevent, so that if a director is needed to be removed and it's done properly by, whatever is stated, the 2/3 vote, all that kind of stuff, that there's no or a less of a chance that person is going to still go through the litigation and appeal all of this and fight it,
So I guess what I heard Jim say, and maybe extrapolating from what Laura's saying, that you guys feel that your advice to the board would be that we consult with our corporate counsel before taking any steps on this, that you feel like you're out of your depth as a committee. And I certainly, respect that assessment.
Well, I
and
don't want
respect
it to-
that as an option.
I don't think we're, or maybe I'm just misinterpreting, but I don't think it's that we don't want to pass the buck or anything like that, or that it is out of our realm. But I do think there's a valid guidance part of it that they're on retainer for. We should be
Right.
trying
Yeah.
to make this so that we are in good faith, having things worded to help prevent or lessen the opportunities for someone to keep taking things, questioning them, and taking it to court.
Okay.
You know, and so if I don't see why we wouldn't be able to ask for some guidance. You know, how
Yeah.
detailed should this topic be? I've got to go back. I don't have a copy of my own like PTA bylaws, but we do include specific parameters on how to remove an officer. You know, so that it is very clear what steps need to be taken in order to even consider it, and all of that. And I want to relook at those words before I even suggest and continue a possible suggestion for that might fit for us as a homeowners association. So I hope we're going to be able to continue these discussions at the next meeting. But
Can I just, one point, if I may?
Go ahead, go ahead.
Yes,
Yeah,
sorry.
I think Laura makes a good point, but I think there's, in terms of getting advice from counsel, which I think is a good idea, there's sort of two questions. One is, in any case involving removal, whether it's for cause or not for cause, you know, the likelihood is going to be the aggrieved party is probably going to run to court. I mean, let's be honest about that. But the question, and the initial question is, are we better off removing, as I think Keith suggested, the term for cause, or and what's the impact of having nothing in there or having a statement for cause in there? The next question that council should address, if we're going to go that route, would be, if we're going to leave for cause in there, how do we define that? Whether it's a laundry list or it's a general behavior situation or something like that. And I would think that that there may be a couple of places to look. I'm just wondering, because I don't know the answer to this, is whether or not there is, for instance, an association, national or even in Maryland, of homeowners associations that could provide some information. My very quick reading of the statute was essentially comes down to the homeowners association, any association is required to operate in an open fashion and keep its members informed. And as a general rule, the notice was always, you have to have notice out there so that the members know what's going on. But if you're going to take some sort of internal action, like removing a director, then you're on your own. I mean, that's sort of what, to me, as I recall, and it was a quick reading, so don't hold me to this, but that's sort of the way the law was written. So it would seem to me there's sort of two questions. One is, do we pursue this at all, or do we just take for cause out of there? And then if we're going to pursue it, we're going to have to get some background information and get some help, I think.
I just feel like the lawyer would be able to say to us, if you leave out the word cause, that's going to be a huge problem, yes or no. You know what I mean? They should be able to say, from our experience, we've seen multiple cases that have made it all the way to court, you know, because of either or situation. Tell us which one that is so that we can do the opposite and make sure that we're trying to at least set it up so that we lessen the opportunity. We're never going to totally eliminate the opportunity, but shouldn't they be able to say, oh my gosh, please don't take that word out. We've seen so many cases, you know, where people argued against that and won, you know, versus saying you don't need to specify the cause. You know what I mean? That's the guidance I'm looking for.
I think that's true, and my guess would be you'll find cases, precedents on both sides. The concern I have, and again, I'm a retired lawyer, so I don't like to give advice, but my concern would be if you don't have something in there, you're opening yourself up to a more egregious claim against you, which is you've denied them their rights, as opposed to you're arguing about whether behavior X is a violation of the code that's in your bylaws. So I agree. That's why I say there's two questions. Do we do anything, or do we take the language out? What's the case law on that side? If we leave it in and we present some sort of list or recommendations or whatever, what's the case law on that side? But I agree with you. I think in either case, you potentially will always be subject to litigation. You're not going to close the door to the courthouse on this one, that's for sure.
Okay, Colette, I'm not sure. I'm not sure that this reflects the consensus of the committee. I really think the board needs to rethink what they want us to do with this.
Okay, I think that's a fair statement.
Yeah, I just kind of leave it at that for right now.
Okay. Yeah.
All right,
Bob,
guys. I'm
I
sorry.
think
Go ahead,
Bob
Laura.
has-
Bob. You want
Yeah,
to?
the only question I have, and I agree with what everybody said, but it's no different than terminating an employee. What's the reason or what's the cause? You need to justify it because you're going to wind up in litigation depending how you handle it.
Yeah.
I mean,
Mhm.
so I think the board needs to give us some more guidance. What do they really want?
Okay, sure.
Okay.
Okay, thank you.
All right. The last item on the agenda is to schedule the next meeting. Let me make just a personal comment. Unfortunately, I am right now not a very enthusiastic in-person meeting individual. I have been through I don't feel good. I test positive. I'm isolated. I've been through the IV at Tile Health Regional Center in Salisbury. I'm out of isolation now and feel pretty good. I wasn't particularly active in the community. Before that, I'm fully isolated. I'm sorry, vaccinated. And am now feeling my way back to some degree of normal activity. I don't see any, at this point in time, a problem being able to participate in a future board meeting that we talked about. But right now, I'm not very enthusiastic about close personal contact and in-person meetings. I think we need to schedule a meeting for fairly near term. We have been going on for a while on an every 2-week basis, and I think we're pretty close to being back on that. And my suggestion is 2 weeks from now is the middle of the Thanksgiving weekend, which I think is out of the question. I would like to suggest we get together again on December 3rd, and I would like to propose again a Microsoft team meeting at 1 o'clock.
That works for me.
Jim, that's fine. I did not know the situation you're in right now. I also did not know, frankly, that Laura is not here all the time. I was not aware of that. As a new member, I thought it'd be nice to be able to sit down face to face with my fellow committee members, but that's fine. We can hold that in abeyance and do it at some other point when everybody's ready to do so.
Right.
My only request is I'm going to get in touch with Josh and see if I can find a time to go over, and I'll bring my laptop over so I can get this thing resolved. But that's fine. I raised it only because I'm the new guy and I wanted to be able to meet my fellow committee members. But at a time that's convenient for everybody, I'm good.
I think everybody I think everybody agrees and appreciates that. And to just make sure to clarify, I have come out of isolation. I was on isolation until this past Wednesday, but the Department of Health has sent me a letter that says I'm good to go. Now, my problem is how good do I feel to go? I expect to be wearing a mask
Right.
virtually anywhere.
Well,
Publicly.
I'm becoming more of a 3/4 resident. We're not quite ready to say we're full time yet, but I do have to like go back to our other home for the month of December because I'm going to be able to be there with our other children for the Christmas holidays and all that. But when we're back in January, we will probably be here for a couple of months, so at a stretch, because I have a son with a physical disability, so we limit how much traveling we do back and forth. But he's also considered high risk, so if the rates are higher, I would prefer to stick with team meetings too for a little bit, just to limit the in-person. But I'm not opposed to doing it at some time, later in the new year. Let's just make it sound like it's far away. Next year, sometime in 2022. Okay.
But by the way, that's fine, and I will commit to bringing the coffee and donuts to our first in-person meeting.
All right, we'll go with December 3rd.
Yeah, December 3rd. Me.
Okay. Any further business for the committee? Okay, hearing none, I'm going to take it that we're all in favor of continuing on with the Friday activities, and everyone have a good weekend. Thanks for everybody being here and participating.